Well, hello everyone out there. This is Mark Ucini. I'm a director with Vector Health, and on behalf of FieldFisher, Gardner Law and Vector Health, I welcome you to our webinar on US and EU transparency reporting regulations update. We'll be talking obviously about transparency updates and then the current situation, as well as some related topics like the DOJ settlements, the Speaker Bureau alert that came out a while ago, some very timely and interesting topics we hope you feel. So I wanted to go ahead and jump into things a little bit. First, I'd love to introduce our panelists who we have on, who I hope you can see here today. We've got Mark Gardner, Amanda Johnston, Dr. Cord Wilhooft, and Ned Mumtaz, and they'll be introducing themselves a little bit more later in the show. I'm excited. They bring years of experience and insights into the topics that they'll be covering today. Just a quick perfunctory disclaimer. The information that we're going to be provided is provided just for general information only. It does not constitute business or legal advice and should be taken in that regard. The outcomes and best practice guidance, regulatory requirements may differ depending on your specific situation. And of course, all information shared, all opinions expressed are being done in an individual capacity and don't necessarily represent the views of any of the respective organizations. A few housekeeping notes, and I have some other team members on the line, so they may jump in if there's anything else I forget to mention. First and foremost, your microphones currently are muted. If you run into any technical difficulties at all, you can either use the chat window, which hopefully all of you have at this point, lots of familiar with Zoom. You can see that at the bottom of your screen. Just go ahead and chat something in there, and we have a couple of folks to help you out. Alternatively, you can see the phone number there. Please feel free to use that. The other thing I want to make you aware of is you have the Q&A box. Please do use that for any questions or comments you have. We're hoping to get into the questions during the webinar itself, as well as at the end. And then lastly, just for you to be aware of, we are going to be recording this webinar and posting it on our websites. So your questions will be made immortal. A quick little reminder of some upcoming events that are going to be happening. There is going to be a June 17th commercial medical technology webinar and a July 1st performing medical technology transactions in Europe webinar. So do keep your eye out for that. If you want more information, you can find that on the Gardner Law website. So before I hand it over to a couple of our presenters to cover the US and state federal transparency reporting, just wanted to warm you guys up a little bit with a couple polling questions, get a little feel for who we have on the line today. So if I could go ahead and pull up the first question, which is going to be around what type of manufacturer do you work at? So I just want to give you about 30 seconds or so to go ahead and give us your answer. Wonderful. Okay, we'll just be wrapping that up in the next few seconds, and then if our colleagues on the line could share the results with everybody. So it appears we have a medical device in the front runners today, but not followed too far behind by biopharma, and so pretty even split there. We do have some more people joining here in the next few minutes, so that might change, but pretty even split, I'd say. Excellent. And then we're just going to bring one more question online, and I just wanted to get a feel for the experience level on the call today. Do we have a bunch of hardened veterans or people who are new to some of the topics? So the question is, how much experience do you have in US and global transparency reporting? So again, I'll give you just 20 to 30 seconds to reply to that easy question. Excellent. Looks like we've got the results coming in here. There are about a quarter of the folks who are experienced in both US and global. Very interesting. With the largest group being folks who are focusing on the US and folks who are new to reporting. So hope that gives a little insight to the speakers here as we go into their respective sections on the US and global reporting sessions. So very interesting. Looks like we've got a good mix today. All right. Well, thank you guys very much for that little bit of information on who we have here today. And what I'd love to do now is go ahead and turn it over to Mark Gardner and Amanda Johnston to cover the US federal and state transparency reporting update. Mark, I'll turn it over to you.
Mark. Yeah, appreciate that. These are our bios. You can read them. I won't spend a lot of time on this. My background, I've worked in the industry for 21 years now, healthcare. And I started out at laboratory, then went into med tech as a product manager at a couple of companies, and started practicing law 12 years ago, and worked at a boutique firm initially, and then started Gardner Law 5 years ago. We have a team of about 15 now, including lawyers and non-lawyers. I also teach drug and device law at a local law school here in Minnesota, where we're based. We're in Stillwater, Minnesota, which is outside of the Minneapolis-St. Paul area. Amanda, do you want to introduce yourself briefly?
Yeah, sure. Hello, everybody. Thanks for joining. My name is Amanda Johnston. I'm a managing attorney at Gardner Law. I joined about 2 years ago. And so prior to that, I was in-house, primarily doing compliance and regulatory work. I have 10 plus years in healthcare at United Health Group, Medtronic, and Coloplast, and I'm also an adjunct professor at Mitchell Hamlin. So yeah, nice to meet you, everybody.
Thanks. I'll just say also that our firm focuses 100% on drug and device law. Transparency is one of the areas of focus. We'll talk about that today, obviously. So here's our agenda. I will roll through the Physician Payment Sunshine Act, i.e. open payments, fairly quickly. I know we've got kind of a blended audience here, which I assumed we'd have people of all, kind of at all levels in the transparency regime, if you will. Some experts out there, some more novice. So we'll get you acclimated. So we'll go over the Sunshine Act, as I'll call it. We'll then cover some changes. Amanda will cover those changes and some recent enforcement actions, which I suspect a bunch of you are interested in. That was one of the items that we wanted to get into and marketed today for this program. It's really recent contemporary actions. We can discuss a bit there. I will then cover the state sunshine laws or marketing laws. Depending on the state jurisdiction, there are different rules, and some apply to drug makers only, others drug and device. And then lastly, Amanda will talk, and I will talk about the impact of the OIG Special Fraud Alert on speaker programs. All right, so let's start with an overview of federal transparency reporting. This is going back to August 2013 is when the law went into effect. So it's been around now for a number of years. Why does it exist? Chuck Grassley and Herb Kohl, senator, now retired Herb Kohl from Wisconsin Democrat, and Chuck Grassley is still a senator, a Republican senator in Iowa. And they came up with this legislation where they said, we want to have all the payments that industry makes to physicians and teaching hospitals to be publicly displayed. And that's expanded a bit now to include some nurses, which we'll talk about in a minute. But the idea is they're thinking, well, this will deter bribery, and it also will allow patients to be able to see if their physician is on some sort of engagement with a company that's making their drug or medical device. So it's essentially, for transparency purposes. Of course, that's becoming more and more prominent. There are many jurisdictions that now have these sunshine laws in place. We don't have one for politicians yet that I'm aware of, which would be interesting to see who's paying the politicians, but not sure that that's going to happen. We can go to the next slide. Who does it apply to? Applicable manufacturers, and this is right from from the law, entities engage in the production, preparation, propagation, compounding, or conversion of a covered drug, device, biological, or medical supply, which is sold or distributed in the U.S. So, as we all know, the FDA approves medical devices, drugs, biologics, and there's different thresholds for when they require pre-approval. For example, over-the-counter drugs and medical devices do not require pre-approval generally, but most prescription drugs, they all do. Medical devices are actually also prescription or non-prescription as well. We won't get into that, but just suffice it to say, if you have a product that is a prescription drug and it's reimbursable, this is the test that I'm covering here, that last bullet, then you're an applicable manufacturer, and you have to report any payments you make to teaching hospitals and physicians, which includes nurses, as I noted, and some types of nurses. You also have to report research payments and also ownership. I'm getting a little ahead of myself here. We'll cover that in the next slide. One other point, if you're a medical device or medical technology and your device requires pre-approval or clearance, 510K, pre-market notification, for example, then your device is a covered device and you have to report as well. So it gets a little bit nuanced, but those are the basics. So just to kind of to cover that again quickly. So if you have a prescription drug and it's reimbursable, it's a covered drug. If you have a medical device that requires 510K clearance or PMA approval, or is, for example, an IDE medical device and category B reimbursement is available while it's being researched, studied, then it is also covered. But those are the basics. So what do we have to report? Let's go back one, Mark. Thanks. General payments. Oh, yep, there we go. So payments that are $11.04 or greater. By the way, it started out in August of 2013. It was $10, but inflation has caused that number to go up. So the amounts are adjusted to CPI, count for increases in inflation each year. So if you make a payment, like take a doctor, near applicable manufacturer, you take a doctor out to dinner and it's $20, then that payment is above $11.04. So you'd have to report that. If you took someone to Subway and it was, what is it, $5 footlong, to recite the commercial, that would be below the $11.04, so you would not have to report that. However, if you took a physician to Subway every day for a year, then there would be an aggregate threshold above that is met, be above $110.40. So you'd have to report then all of the Subway sandwiches that you purchased. Other things to report: research payments, and as I noted, ownership or investment interest. Last point here: Sunshine Act does not bar payments or ownership interests; it just requires reporting of them. Who do you report to? CMS. And this is a process that probably most of you are familiar with now. Once the data is reported, it's publicly available on openpaymentsdata.cms.gov. So you could literally, go on the internet right now and see what's been paid to your consultants. Sometimes companies like to do that to see if their competitors are using the same consultant. We can go to the next slide. I'll just cover one point on that previous slide, just that an officer of the company has to attest to the results, so that they're accurate and whatnot. Here's the language: the information reported is timely, accurate, complete, to the best of his or her knowledge and belief. Okay. Who are covered recipients? And again, I'm going kind of quick up front here because a lot of this is just 101. We want to make sure we have adequate time for the other topics that we're covering today. So a physician is not just a physician in the general sense where, there'd be a medical doctor, a DO. Physician includes MDs and DOs, but also dentists, podiatrists, optometrists, and chiropractors. Fellows, sometimes that question comes up. Well, is a fellow like a resident? No, fellow is a physician under the law. A resident is not, interestingly. And then there are certain nurses. This is a change that just went into effect. Last year, you had to start to track these individuals, but physician assistants, nurse practitioners, clinical nurse specialists, certified registered nurse anesthetists, or certified nurse midwives. Those are now outlined as in scope. We can go, oh, and teaching hospitals, we also have to report them. People often ask, what's a teaching hospital? That's a hospital that trains students and they get paid by the government, by CMS to train those students. They accept funding from the government. So they're in scope as well for reporting. Indirect payments, I won't read this slide, but early on, doctors kind of got smart, so they thought, they said, well, I'm just going to set up an LLC. It's going to be, Bob MD's consulting LLC, and then I'll escape reporting. My name won't show up in payments. Well, that doesn't work because the money goes from, say, manufacturer X to the physician's LLC, and then quickly goes from the LLC to the physician, or whether it's quick or not, it doesn't matter. The physician owns the LLC, so that would be an indirect payment, has to be reported. We can go to the next slide, Mark. Okay, kind of interesting. Again, most of you probably know this already, but when do you have to report by? What other dates? So generally March 31st of every year. The law actually says the 90th day of every calendar year. So you get into this kind of mathematical issue with the calendar, and you have leap year and all this business. But essentially, CMS has said March 31 every year so far, and sometimes they've even extended the deadline because there's a computer issue or whatever it may be. But you should plan to have your report in by the end of March every year. The earlier, the better. April 1 to May 15, this is a review and dispute period. We just went out of that. So the physicians can go online in teaching hospitals, and they sometimes do. Teaching hospitals are more active with this, and they'll say, we didn't get this payment, we didn't receive this. And then you can show them, hey, actually you did, here's the evidence, or maybe there's a clerical error, and you would then say, oh, okay, well, we'll take that payment back, or we'll delete it. May 16 to May 30, manufacturers are notified of disputes. If a manufacturer does say, hey, we don't agree with the physician or teaching hospital, then those payments will be reported and marked as disputed. June 30th, the data are published, so that's coming up here at the end of the month. After July 1, what if a physician learns that something was wrong, or the company forgot to report something? What happens after July 1? Manufacturers can tell the government, but nothing will change until the following reporting period. Okay, go to the next one. These are the different natures of payments. So buckets, that you have to report the payments under. And I know Amanda and I have been challenged trying to figure out, sometimes you get just something that doesn't fit within one of these buckets. But the government just wants you to do your best. They did have an other, this is going way back, dating myself a bit, but because I want to say the rule first was published, the proposed rule around 2010, and then the final rule, was put in place, and then reporting started August 1st, or I should say tracking started August 1st. 2013, but way back when, before the rule was final, they did have an other bucket, but they took it out because I think they assumed people would abuse other. So you have to pick one of these. If you make a payment to someone and one of these does not line up, I guess there's 18 categories now. You just have to pick the best one. The ones in red are the ones that were just added. I won't read through all these, but it's things like consulting fees, gifts, entertainment, royalties, charity, education. You can read it for yourself. You may be saying, well, Mark, you're not supposed to give gifts, and you're not supposed to entertain. And, AdMed and Pharma do allow for certain types of gifts, those that benefit patients and are $100 or less in value. But entertainment, I can't really think of any code that allows for entertainment currently. So the government, again, isn't saying, they're not trying to prescribe behavior here. They just want to know what manufacturers are spending money on, and the transfers of value that ultimately make it to the teaching hospitals and physicians. That's really what they're interested in. Okay, we'll go to the next slide. Research payments, quick, sometimes you get a question, well, what is a research payment? And here's the definition: systemic investigation designed to develop, contribute to generalizable knowledge relating broadly to public health, including behavioral and social science research. So I think we all know what research is, but that's the official bucket. So I don't think marketing research is going to meet this payment, or this category rather, or definition. It's really, this is about your typical clinical investigation. Perhaps some bench research would also be acceptable, animal testing, etc. Let's go to the next slide. Reporting ownership and investment interests. Something here is just kind of a practice tip for you all. When you do have to report the ownership and investment interest in your company. So if you're working at a startup, or let's say the founder is a physician, you have to report their, any family members that are employed by the company, you still have to report them. You don't have to report general payments. Like if you buy them a meal on the road and they're an employee, you don't have to report that. But if they're an investor in the company, even if it's the CEO and they started the company, if they have ownership in the company, that has to be reported. And what's kind of interesting is this goes even further. If you have an investor who is, let's say they're a CPA or whatever, they're a banker, but their spouse is a physician, or they're even get down to spouse of a grandparent or grandchild, you're going to have to report that as an investment interest. We once had a client send out a letter to everyone asking them, all the investors, there's like say 40 investors, do you have any family member, and going through all of these different types of family members, even getting to step brother and whatnot. Do you have any family that is a physician and meets one of these definitions? And I told them, hey, you don't have to do that. Actually, the final rule does not require you to go out and pretend you're Sherlock Holmes and figure out if everybody's if who's what. So just a practice point for you. If you have knowledge that someone is a physician, and of course, if they're an immediate family member, you have to report that, but you don't have to go and investigate. These are some exceptions, just to give you some taste. Indirect payments or transfers of value made where the applicable manufacturer is unaware of the identity of the recipient. This can't be abused. This is an example where this would maybe come into play would be you are making payments for market research and you need physicians, but it's a double-blinded research, kind of like you think of like Madison Avenue type of research, where you absolutely don't want to know the physician who they are, and vice versa, they can't know who you are. Then that would be there's an exception there because you're totally unaware. But you couldn't, on the other hand, go to a CME or and say, well, we're going to earmark these funds for a physician that's going to speak about some topic, and then you later learn that physician's identity. You're going to have to report that. We can talk more about that if y'all have questions, but that's the basis. As I talked about earlier, another exception is if the value is below $11.04 or $110.40 in aggregate, then that's not reportable. Product samples, educational materials that directly benefit patients, so on and so forth. We can go to the next slide. For corrections, I won't spend a lot of time on this. If you guys have more questions, we can get into that. But suffice it to say, if you do need to edit data, you can do that. Let's go to the next slide. These are the fines. Again, I won't belabor this. You can get fined if you don't meet these requirements. Unintentional violations, lower fine compared to intentional. The good news is the fines do max out at 1.15 million, which is, a pittance compared to some of the FCA AKS settlements that we see. We can go to the next slide. Amanda, I will hand it over to you to talk about some of the changes.
Yeah, sure. Thanks. So some of you may know, if you've been reporting for a few years, that there recently was some changes made to the definition of covered recipients, some of the nature of payment category changes, and I'm just going to go over those briefly. Go to the next slide.
And Amanda, I'd love if we could reach out to the audience just to poll them real quickly to see where they are in the 2021 change process. So if we could bring up a polling question about that right now, hopefully the audience can see that. I'm just going to give you guys about 30 seconds to read the question. Essentially, we're asking you if your organization has already fully tackled all the changes and is ready to go, or if you're currently in progress, or if you're still evaluating the changes that need to be made, both from a collection standpoint as well as from a customer verification and report generation standpoint. So give you just a little bit more time here, and we'll see how the results roll in. Okay, and here come our results. Looks like, Amanda, the majority are, it's kind of evenly split amongst the first three, more or less, but it looks like a good number are in progress as we're halfway through the year here. That's quite interesting, I think.
Yeah, that is really interesting. Okay, good. Well, a lot of this will be helpful for the majority of you. That's great. Let me just, there you go. So just a little bit of background about the changes, or what prompted the changes. So it was actually the Support Act that was signed by President Trump in 2018, and kind of buried in there was this expansion of the Sunshine Act. So the final rule came out in November 2019, and we'll talk a little bit about some of the changes and how they impact how you're tracking data and then what you're reporting. And we have the link to the rule there. You can always look at that later. All right, so kind of the most significant change, I guess, in terms of kind of logistics in your company and policies and tracking is really the expansion of the definition of a covered recipient. So of course, it's kind of historically been just physicians and teaching hospitals. As Mark mentioned, that definition of physician was a little broader than just MDs. But now we're expanding to include several categories of advanced practice nurses. And just a reminder to clarify that these changes went into effect on January 1st, 2021. So you all should be tracking, or at least working towards tracking and capturing this data for these additional covered recipients. So yes, as Mark mentioned, PAs, NPs, clinical nurse specialists, certified registered nurse anesthetists, and then certified nurse midwives. And again, there's kind of some nuances to some of these definitions. So we encourage you to kind of do that, do the analysis on the covered recipients, but it's always better to track and then figure out later if you need to report or not, versus trying to, go back in historical sign-in sheets to try to figure out if somebody was a PA, for example, or a CNS. Notably, so registered nurses are not on this list. So there's there's still some nurse professions that are not reportable, but some of the states may require reporting. So we always encourage people to consider tracking data and spend for really all healthcare professionals, just so you have that data. All right, and then there are some other, like the NPI changes. I'm not going to go into detail on those. So kind of the next big change or changes is to the nature of payments. So some of the nature of payment categories were modified, and then there was actually 3 new categories that were added. So there was a category added for debt forgiveness. There was one for long-term medical supplies or device loans. So this often comes into play if you're doing like a product evaluation and the customer ends up having it longer than 90 days. So as you may know, after 90 days, it is reportable. And so this would be the category that you would use for that type of a scenario. And then acquisitions was also added as a nature of payment category. Go to the next slide. And there was previously 2 different categories for continuing or for education programs, and now they've consolidated them into kind of a continuing education program. So it's medical education programs is the category. So it was previously distinguished between accredited and certified and unaccredited and non-certified, and now it's just one bucket. Go to the next one. All right, and I'm not going to go into detail on this one, but there was a reporting requirement that was added for the device identifier component, and this actually might be kind of might be some work for a company that has a lot of payments to report. So the device identifier is it's the mandatory fixed portion of the UDI, and so that needs to be reported as well. And then NDC codes are required again. All right. And then just kind of, this happens every year, as Mark noted, with inflation, but just the official new transaction thresholds for reporting were finalized for this reporting year. So 1104 per transaction and 11040 is the aggregate annual threshold. All right, and as I mentioned, so we should be tracking starting January 1st, 2021 under these new expanded definitions. And so March 2022, so next year, which will be the 2021 program year, that's when that will be the first time that we're reporting under this expanded definition and the changes to the nature of payment categories. Go to the next one. All right, and I think Mark and I will both kind of jump in on the enforcement. This is actually really interesting, as many of you know that have been in the industry for the last 10 years or so. When the Sunshine Act came out, 2013, 2014, and there was not a lot of enforcement. We didn't hear really of any. I think anecdotally, I've heard of companies getting letters from CMS reminding them to report, or kind of nudging them like, hey, you might want to consider, checking to see whether you need to report. But there really hadn't been any, enforcement activity at a formal level. And so this has changed in the last year, especially in the last 6 months. And so we'll talk a little bit about kind of the current status of enforcement activity here. All right, so this I think is actually the most recent case. So Medicree, I'll probably butcher it. This was just recently, just last month. But essentially there was a settlement between the OIG and Medicree, which I think is a French company. Yeah, a French manufacturer, Medicree International. And so they ended up settling with the government, and they're paying $1 million for anti-kickback statute and false claims act allegations, and then also $1 million for Sunshine Act violations. And yeah, go ahead, Mike.
I'll just add here that we're thinking that we're just going to see these fines tacked on from the Sunshine Act in these cases somewhat regularly. It's already started, we believe. And, these fines are fairly modest compared to some of the billion-dollar settlements, again, that we've seen out there with FCA and whatnot. But it's sort of playing for the prosecutors. And they're also sending a message to industry that this law is important and you need to meet it. But yeah, it's somewhat interesting because of, in this case, you had physicians that were U.S. physicians going over to France for a conference. And the manufacturer was also foreign, didn't know that, perhaps they didn't even know the Sunshine Act existed. They didn't appreciate that. I would think that these payments would be considered bribes and create issues for them under the False Claims Act as well. In this case, it wasn't litigated, it was settled. So, these are, again, allegations, but so we'll never know if they were really truly bribes, for example. They truly
Right.
would violate the FCA and the kickback statute. But nevertheless, it's just it's sort of an interesting case, given that you had physicians going outside the United States and a foreign manufacturer that was ultimately prosecuted.
And that it was in 2013, which was, you know, very, very early days of the Sunshine Act. So it's interesting that that it was picked up on. But yeah.
Yeah, the government has a memory of it.
Yes, exactly. Yes, exactly. All right, you can go to the next one. So this is another recent case, and Mark, feel free to jump in if you have any anecdotes to share. But this was 2 medical device distributorships. Actually, medical device companies, I think there was a relationship with a neurosurgeon-owned distributor, so a pod. But essentially, they agreed to pay $100,000 in penalties to settle allegations that they violated the Sunshine Act. So they failed to report the physician ownership in the companies, and also general payments made to covered recipients generally. And then I think just a really important one here is that the parties involved are excluded from participating in federal healthcare programs for 6 years, which is a big deal. I mean, it's essentially a business ender for the parties that were excluded. But yeah, so this is another very recent case. I don't know, Mark, if you have any other details to share on kind of the facts or the unique situations or scenarios here.
Yeah, no, this was, like you said, you had a physician owner who was involved in these 2 companies, and ultimately, you know, there was other issues around the government claiming that there was disinduced purchases that were medically unnecessary and whatnot.
Yeah.
This is tied to the Medtronic case as well that we'll chat about next. Maybe we'll just skip to that one.
Yep. Yep. So this is the Medtronic settlement from November 2020. A lot of you may be familiar with this or remember it. A little higher, you know, dollar amounts here. So they essentially agreed to pay 9.2 million, and 1.11 million of that was related to Sunshine Act failure to report. So this is kind of an interesting fact one. The allegations are under the anti-kickback statute and the False Claims Act, but essentially they were using a Brazilian grill restaurant and holding events there. And they allegedly knew that it was owned by a neurosurgeon customer, and they failed to report the payments to the Brazilian grill to the physician that owned it. So yeah, interesting case. You can see, you know, the 1.11 million close to that cap. I'm not sure why they didn't go for the 1.15 million, but it must have been just how the math added up. But yeah, it was an interesting one.
Yeah. So in this case, the physician owned the grill, and you know, this would be where we talked earlier about indirect payments. This would be a great example of an indirect payment. The physician owned the restaurant, so any payments made by Medtronic to the physician owner of the restaurant, even though it's through the restaurant, would still have to be reported.
Yeah.
And you know, the government said, hey, you really did this with the intent of bribing the physician. That was their argument. And so you violated the AKS and FCA.
Yeah,
well.
and I think in this case, it was not just a couple events, it was a lot of events,
Yeah,
which is kind of another fact that probably contributed to the fines that we're seeing in the settlement.
Yep.
All right, and then Lifespine, which was actually in 2019, and if you guys remember, this actually did not include any penalties related to the Sunshine Act or Sunshine Act violations, but the government did note that they failed to report over $7 million in payments. So it's interesting that they referenced it, but did not include it, you know, as part of the settlement. So we can kind of see the evolution. Again, this was from 2019, and now we've seen, you know, 3 cases, essentially 3+ cases where they are actually tacking on fines. But this one was basically payments made between Lifespine and physicians, and it was consulting fees, royalties. There was some intellectual property acquisition fees, and there was just payments going to the physicians that allegedly were not reported under the Sunshine Act. And so they did reference that they weren't reported, but it wasn't actually included in the settlement. But it was a AKS and False Claims Act settlement. All right, we go to the next one. And then Mark, I think, yeah, if you have any comments.
Yeah, I'm going to cover, I think we're good on the cases. If you all have more questions about the case, we're happy to entertain those. We do have a bit more on our website about the cases as well, and links to the DOJ settlements in case you want to read those press releases. But I'm going to talk now about.
Mark,
yeah.
there's a question I think that just came in around the Medtronic case, if you want to see that.
Sure, can you read it to me? Because I don't actually, here it is. I've got it now. The Medtronic, was it argued that the physician owner was not providing services in his capacity as a physician, and therefore an exception should have applied? Yeah, it's a good question. So I'm going to try and providing services in his capacity as a physician.
Yeah, I'm not familiar enough with the facts to know if that was an argument that was made. But it is a good point, because there is that exception if they're not providing, physician services. That
Right. Yeah, that's a good point. So like if you hired a physician to be an expert witness or in some legal proceeding, I don't know if that's a great example. Let's make a really silly example. If you had a physician who went to medical school and decided their real calling was accounting, so they went on to become a CPA, but they're still an MD and they kept their license up even though they're practicing as an accountant. If Medtronic had paid that technically physician, to do their taxes, then that would not be a reportable payment because you're not paying for medical services.
Yeah.
In this case, yeah, I mean, it's a good point. What if they had argued, well, we're actually, the physician is making Brazilian steaks for us. So that's, they're not practicing medicine. I don't know, Medtronic is obviously very astute, sophisticated party. Perhaps they did, but this was a settlement. So, they might have just said, okay, it's billion 1.15. And I don't know, man, maybe they might have rounded up in that. Maybe this is what the government reported as 1.1. I don't know, but yeah, no, that's a pretty astute comment from that attendee to the webinar here today, but hard to say. That the government might have just said, well, we don't care. We want to get this press release out there, and they might have just went for it. We don't know.
Yeah. But yeah, good
Mark,
question.
if I may comment on this from an EU perspective, this is indeed a very good point, because under the EU and the European sunshine laws and industry guidelines, this would indeed exclude from the scope of the disclosure rules, because only payments or transfer of value in connection to the medical profession of the physician or the healthcare organization must be disclosed. This could be a relevant point for corruption, because maybe if the meal is overpriced, or it's just a circumvention that you're not allowed to provide financial benefit to a physician, and you do it via the artificial scope of a grill or a restaurant, that would be relevant. It would not trigger the application of disclosure rules because of this point that you put it.
Interesting. Yeah, that's good to know. Okay, let's talk a little bit about the states. I'm going to go fairly quickly through this because I don't want to take time for Cord and Ned here. So again, if folks listening have questions about this, feel free to follow up with us or ask them in the Q&A part. So California has a state law that applies to drug and device makers. There's some controversy as to whether it applies to device makers, but the device industry is more or less acquiesced to the California rules, or at least has attempted to comply with them, depending on the part of the law. And I won't bore you with that too much, but the law defines dangerous drug as a medical device as well. But then there was some controversy over where people were saying, well, that was really intended for like a meter dose inhaler for asthma. That's the device component. It's really, the law is really supposed to be for pharmaceuticals, but most device makers attempt to comply with it. There's no registration or reporting, but you have to report certain things on your website. You can see it here on the slide. Everyone will have access to these slides, which is why we're kind of not reading them completely to you today. So if you have more questions on this, you can follow up with us. Interestingly, you have to set up per physician dollar limit on gifts, promotional items, activities provided that are associated with the healthcare professional. Let's go to the next slide. But just to be clear, in California, you don't have to report anything at this time. Massachusetts, this applies to drug and device makers. You have to register if you're essentially selling or doing business in the state. And you also have to report basically it's like a mini Sunshine Act within the state for payments $50 or more. There is preemption for physicians and PAs and whatnot. So if you're already reporting that to the federal government, you do not have to re-report it to the Commonwealth of Massachusetts. But if you were making payments to a physical therapist or an RN or someone like that, you would have to report those to Massachusetts. Failure to comply, $5,000 per violation. Let's go to the next slide. I'll just say one other thing about Massachusetts. There's a lot of marketing rules there as well, and they do have a guide, an FAQ guide available, but they have rules around that are related to anti-bribery. They're sort of like AdvaMed pharma codes that are, have been codified into the law in Massachusetts. Vermont, probably the most strict law, kind of keeps things easy though. You can't provide any meals. There's no gifts, no nothing to any practitioners in Vermont. They do allow like consulting engagements and whatnot. Their law does apply to drug and device makers. You have to pay a fee and register if you're conducting business in the state. Interestingly, if you don't have anything to report, you don't have to register. So you can save your $500 there. Things that you would report here, again, the payments to physicians and the PAs and whatnot would be preempted, but then anyone else, like a tech or a nurse that's not one of the types of nurses that is now covered under the Sunshine Act, those payments would have to be reported to Vermont annually. Let's go to the next slide. By the way, real quick, up to $10,000 a fine for Vermont. Some years back, they did have an amnesty program, which then turned into a not so amnesty program. And I won't get into it, but they encourage manufacturers to come forth if they had been providing gifts and that they would be granted amnesty. And then they turned around and prosecuted the people that came forth, which was kind of bizarre. Nevada, this applies to drug and device makers. Again, there's dates in each of these slides. You'll have that information, but here you have to, by June 1 each year, you have to say that you're going to do certain things in Vermont. You have to have a marketing code of conduct that you provide to them, a description of your training program, description of investigation policies. For each of these, you have to say who the compliance officer is. Interestingly, and there's a lot more that meets the eye here. It was a limited webinar today, but Nevada and Massachusetts both have auditing requirements. So if you're the compliance officer, you actually attest under penalty of perjury that you've conducted an audit, for example, on your program, and you can decide whether ongoing monitoring is tantamount to an audit or not. But each of these states has, these requirements. You essentially have to sign off on them, and if you don't follow them, then you're under penalty of perjury. Let's see here. Let's go to the next slide. Oh, one last mark, if you can flip back for just a second. Pharmaceutical manufacturers have to report in Nevada, but device companies don't. So you get this kind of weird mixture. Sometimes there's different rules for drug versus device makers. Let's go to the next slide. Okay, Connecticut. you have to report. This was really intended for advanced practice registered nurses, which are now largely all covered by the Sunshine Act. I mean, I can't think of any that aren't. So, you know, there's nothing stopping a manufacturer from reporting twice, but most manufacturers take advantage of preemption, meaning you're not going to report to the feds and the state governments the same information. Let's go to the next slide. Florida, Miami-Dade, this is, so you're getting into the municipal level now. Applies to drug and device makers. You have to register your reps. That's probably something that might be a surprise to a lot of you. And then there's also these sales rep transaction reports that are due. Let's go to the next slide. We'll talk about Chicago. Yeah. This is drug makers only. Again, more of the same. Have to register reps, but you do not have to report regularly transfers of value. But if you have more questions about that, we're including the links on for each of these on the slides as well. All right, let's go to the next one. Minnesota, where we hail from. So this is drug makers only. The law actually says if the bulk of your business is pharmaceutical, then you do not have to comply with this law. So even like a Medtronic, who, you know, the bulk of their business is medical technology, not pharmaceuticals. So even though they sell pharmaceuticals, this law does not apply. I suspect that some lobbying might have impacted how this law applies and who it applies to. Yeah. But essentially here you have to report transactions to made to HCPs, to healthcare practitioners as they're defined in the law by May 1st. The reporting threshold is $100 or more. And there is actually, we can go to the next slide, Mark. There is a limit in Minnesota, and here it is, that you can't provide gifts. The second bullet there prohibits the provision of meals to HCPs that exceed $50 per year. It actually applies to all gifts. But this slide here, which I think I will not read, you all will have this, but this is a overview of state jurisdictions and how their treatment of meals. Let's go to the next slide.
Sure, and just a quick 3-minute housekeeping time check. And then there was one question that came in. I'd love to have you guys respond to. The question was, just paraphrasing, is regarding Vermont. I was under the impression that you still need to register even if you don't have anything to report, and then request a refund if you don't have anything.
That's not my recollection, unless they changed something. The rule was before that you did not have to register unless you had things to report, but perhaps that anonymous attendee knows something that I don't.
Yeah, I was going to say that was my understanding too. I feel like I just had looked into it not that long ago, that there was somewhere written that you don't have to report, or you don't have to register and pay if you don't have anything to report. But again, that could change.
Vermont has an FAQ also, and if you guys need any of those, let me know. I think, Amanda, why don't we cover this really quickly?
Yeah, I was going to say, we want to leave time for, I know Ned's going to touch on this as well. So just really quickly, I'm sure a lot of you have heard about the OIG Special Fraud Alert that came out about speaker programs in November. It's very interesting. And we've, seen a lot of articles written, and people have been speaking and talking and contemplating what this means for the industry. So just wanted to at least bring it up because it's really important and big, and it does impact sunshine reporting in the sense that speaker programs typically involve consulting fees or honoraria, and then potentially meals and travel for the consultant. So just wanted to point it out and just make sure we don't fail to mention it, because it obviously is a big kind of development in the area. You can go to the next slide. And I think we'll probably just go to the considerations, like
we can go forward through that.
Yeah. And so, and we actually have heard there were some events where an attorney from the OIG spoke, and I've also heard some additional commentary by attorneys in the OIG. And really, it's recent cases that kind of sparked this. It's the Novartis case, if you're not familiar, but it involved a lot of kind of whining and dining, and a lot of speaker programs. And so I think this, together with just the fact that, we've seen that virtual programs can be successful as well, as we've gone through the pandemic and have had to, switch gears in terms of not having in-person meetings and not having in-person speaker programs. And so I think they took it as an opportunity to kind of clarify that they really do view kind of the in-person programs to be higher risk. There's higher risk associated with them. But it's also been made clear, when we heard some of the OIG counsels speak, that it really is still a facts and circumstances determination. So they're not saying that speaker programs are illegal. They're not saying that you can't serve alcohol, for example, but it is really a facts and circumstances analysis. It should be a legitimate educational event. The more it looks like a social event, the more suspect it's going to look. And you can go to the slide on with the suspect characteristics just quickly. You guys can read this when we send them out. But yeah, so I won't read this again. But yeah, so again, kind of just going through the factors that they're going to look at in their facts and circumstances analysis.
Just zero in on one, and then we can get over to Cord here. But the second bullet, alcohol. Mark, you can go ahead. So they basically said if alcohol's present, that's a suspect characteristic. Let's go to the next slide. Next one.
So yeah, no, they're not banning speaker programs.
Yeah. We can keep going. I want to get to this. There we go. So go to that chart. So we did a poll. I think we had about 70 people respond or so on LinkedIn, but this was the cut, and some people are saying, hey, yeah, ban alcohol at the speaker programs, because pharma's consider, we've kind of heard some rumblings that pharma's going to ban it. We don't know if that's true, and AbbVie may place restrictions. And a third of people polled said ban it, you should be focused on business, and 2/3 said, having a bar available, maybe even for attendees to purchase something if they want it, or to have a free drink at the speaker program is okay. So kind of some controversy there. Let's go to the next slide. But we have an alert. Let's, we can keep going, Mark. We'll just get up to Cord here. We'll hand it over to Cord, because we have an alert on our website where you can learn more about the OIG speaker program, fraud alert.
Yeah, we have some more commentary and some best practices and just, things to consider that you can take a look at your convenience.
Yeah, so thanks. We'll hand it over to Cord.
Thank you.
Yeah, thank you very much, Amanda and Mark, for this very interesting presentation. Ladies and gentlemen, I'm now very happy to have the opportunity to present you the Sunshine Laws and Industry Guidelines from an EU perspective. A few words about myself. I'm Cord Willuft. I'm partner at the law firm FieldFisher. I'm German qualified lawyer and advising medtech companies and also pharmaceutical companies. We don't say drug makers, we say pharmaceutical companies here in Europe. In particular also about healthcare compliance. And we have only limited time today. So what I don't want to do, or let's say it the other way around, I would like to show you in which legal areas the life science companies in Europe are in a very comfortable position. That means in regulatory and also in terms of healthcare compliance. Because here, regarding medical devices, you have the so-called MDR, the regulation 2017 and 2017-745, which entered into force, or which is applicable since 3 weeks, and fully harmonize the regulatory framework for medical devices. The same applies to medicine product regarding the directive 2001/83. It's a directive, but nevertheless, the space for national legislators is so limited that the ECJ, the European Court of Justice, said already a decade ago that this is de facto a full harmonization. So When you are an international operating life science company, you are very comfortable in a very convenient situation regarding the regulatory framework. The same applies to most of the healthcare compliance rules. We have no harmonization in this respect, but the principles, the underlying principles, are more or less identical. We have the principle of separation, which means there must be no link between payments and therapeutical decision of healthcare professionals. We have the principle of documentation. Everything needs to be documented in writing and also stored for a certain period of time. We have the principle of equivalence, fair market value, you all know this. And then the fourth principle that applies with respect to interactions with healthcare professionals, healthcare organizations, is the principle of transparency. Transparency, not in relation to our main topic today. Transparency in this respect means any kind of cooperation needs to be disclosed, and if applicable, an employer consent must be obtained. So these are two regimes or two legal areas where we are in a very convenient situation. We are not at all in a convenient situation when we are talking about, for instance, market access in terms of pricing and reimbursement of your medical device or your medicinal product. The same applies to transparency law. So transparency law lies still in the competency of the member state or the European country. And that means we have, I will not say a jungle or kind of variety of country-specific solutions. So that makes it very difficult to show you the EU transparency. Sorry, I'm just receiving a call. I have to reject. So what I want to do now is show you how can you deal with the situation. You're an international operating life science company. What is your first step when you're approaching the EU market? First of all, you have to identify certain country of interest.
Hey, Cord, you're kind of quiet. I don't know if it's that way for everyone else.
Is this better now?
Yeah.
Yeah, we can hear you now.
Thank you.
Great. Thanks a lot. I just received a call that I had to reject, and then the settings are turning back to standard. Sorry for that. So what I wanted to say is we have a huge variety of country-specific solution or regulation in terms of transparency. And what I want to do now is provide you with a kind of best practice or steps that you have to take when you want to see what kind of transparency rules you have to deal in Europe. So first of all, certainly, where is the healthcare organization, the healthcare professional, the patient organization, or the representative of the patient organization located in which country? And this is relevant for the applicable regime. And the first step then is have a look if this country provides for a National Sunshine Act. And what I have done is putting together a very brief overview here of in terms of economic relevance and market share, the European countries I have put together on this table. And you can see on the one hand side, Germany has no National Sunshine Act, and the German legislator is currently not even discussing it. The opposite applies to France. The French Sunshine Act already exists since 2011. And when you go down further the list, you see these are in terms of economic interest for medical device companies and pharmaceutical companies, the most relevant 8 countries here. 4 of them have a National Sunshine Act. The other 4 don't. So this is something, when we go to the other slide, I'm very happy to give you 2 examples First, starting with Germany. As I said, we have no German Sunshine Act. And also, we are in a situation where all the stakeholders in the German healthcare system are calling for a transparency law that includes the payers. This includes patient organizations, physician associations, and even our Joint Federal Committee, which is our health technology assessment body. They're all calling for a national transparency or Sunshine Act in Germany. But the German legislator remains passive. And in consequence, what I find very interesting, our Federal Association of Medtech Companies, BVMed, even said, why should we include or why should we establish self-regulatory disclosure rules, transparency rules, if not even the German legislator is establishing this? So this is very interesting. And even these days, 2012 and 2013, OIG published a white paper on transparency and disclosure, and BVMed is a member of OIG. So this is a very interesting situation that you face here in Germany. When we go to the next slide, we can see the other extreme, which is the Law Bertrand, the French Sunshine Act. The French Sunshine Act has initially been created in, I believe, December 2012. And it's just the other way around. Nearly everything needs to be reported on an official website. When you see the list on the right-hand side, there was just an amendment, just something like 5 years ago. 5 years ago, there was an amendment based upon the stakeholders in the French healthcare system nearly needs to report everything. So if any kind of direct or indirect transfer of value exceeds the threshold of 10 euro, it needs to be reported on the official website. The same, it must be reported what is the subject matter of the agreement, what is the purpose of the cooperation between the healthcare company and the physician, and also who is the direct or financial beneficiary. So this is related to what Mark mentioned, even indirect payments. Who is the beneficiary of this payment? So establishing a kind of consultancy LLC would not work, because then the final beneficiary would be the physician running this consultancy LLC. Also quite interesting, very unusual from a German perspective, even payments above 10 euro to medical students or to influencers must be reported on this official website. So this is the first step. These are two examples, what you might experience when you dig deeper into the national legislation. On the one hand side, somebody like Germany not having any national Sunshine Act. On the other hand side, the French Sunshine Act, and I understood from Mark and Amanda, it's a bit like Vermont, if you can compare it with this. You said this is the strictest sunshine rules that you have in the US. So when you make this first step, does my country of interest, where the healthcare professional or the healthcare organization is located, do they have a national sunshine law or not? If you come to the conclusion they don't, then the second question is my company member of a self-regulatory industry association, either on an EU level? Then we are talking about, if you're a medical device company, MedTech Europe, then you can have a look of then you can discover all the transparency rules in the MedTech Europe Code of Ethical Business Practice, which is in part 2. There you can find the disclosure guidelines. Mark, if you may go back one slide, then I'm also happy to refer to the regime or the industry guidelines, the self-regulatory rules that apply to pharmaceutical companies, which is FPR, the European Federation of Pharmaceutical Industry and Association. There you might find in Chapter 5 the disclosure rules when it comes to transfer of value from member companies to healthcare organizations or healthcare professionals. The same when you are not member to this EU-wide industry associations. The second question would be, is my company member of a national industry association? And referring to Germany, we have the BV-Med. There is a code of conduct and the FSR transparency code. FSR is the transparency code that applies to the industry association of research-based companies. Next slide, please, Mark. Very brief overview. What are the disclosure rules for medical device companies within this industry guidelines? So it is indeed the case when you are a medtech company and you are transferring value to a healthcare professional which is located in a country without a National Sunshine Act, you only need to report payments related to educational grants. I think from an US perspective, this is very, very liberal. And you can see here where it needs to be published. This is on the Ethical MedTech Europe website, preferably in English language and in terms of money in the currency used in the payment. If it's not applicable because National Sunshine Acts are higher in the legal hierarchy in relation to self-regulatory industry guidelines, if you have already reported the transfer of value on basis of a National Sunshine Act, for instance in France, then you don't need to re-report or report twice on the MedTech Europe website. And the reporting period is nearly everywhere the same. The reporting period is the calendar year, and the deadline to report is 6 months after the end of the calendar year. So if you made a payment or transfer of value to a healthcare professional organization, a representative of a patient organization or a patient organization, you still have something like 2 weeks to report it, the payments in 2020. Mark, next slide, please, if I may. And this is a very brief overview of the applicable self-regulatory rules on basis of the FPR Code of Practice, Code of Conduct. It's a bit more sophisticated. Everything needs to be reported, any kind of indirect or direct transfer of value in relation to donation and grants, contribution to costs related to events, and fees for service and consultancy. There are 2 exemptions. If the payment is done in the context of over-the-counter medicines, it must not be reported. So this applies, these reporting requirements apply only to RX medicinal products, which are subject to prescription only. And the second exemption is fees for service provided by, for instance, a principal investigator in context of a clinical trial must also not be reported, because this is already reported to the ethics committee in context of the submission or the application procedure for a favorable opinion. Where it needs to be published is relatively comparable to the medtech sector. It's the company website or a central platform, so in the internet, and also either in the English, preferable English language for the sake of transparency, or in the local language. Reporting period is the same, only in the pharmaceutical sector, in these industry guidelines, there is a retention period stipulated for at least 3 years. Thank you. Next slide. I'm closing with a question that we receive very often, because disclosing, for instance, the personal data of a healthcare professional and related payments also means data processing. And data processing, in the US and also in Europe, we have a very sophisticated data protection rules. And this always means you need a justification for this data processing. And you need either a legal obligation to disclose it. So when you are in France, you're subject to the French Sunshine Act, and you're legally obliged to disclose this information. This is a legal ground for the data processing. In Germany, it's a bit different because we don't have a law requiring the companies to disclose these personal data. So the company needs to obtain the informed consent of the healthcare professional, not the healthcare organization, because the data privacy regime only applies to natural persons, to individuals, not to companies. And as you all know, an informed consent must be given, first of all, freely. So the healthcare professional may decide to not give it, or it can be revoked or withdrawn in the future. So in this case, we might have a problem with data privacy when disclosing the payment details, the personal information of this physician. The solution to this is not the individual data will be disclosed. They will be disclosed on basis of aggregated data. So they will be only categorized. So this means, for instance, your company would need to then disclose to whom, in terms of is it a general practitioner to whom the payment has been transferred, for what kind of service, speaker service, advisory board, and the amount that has been paid. So this was a very brief overview of the Sunshine Laws and Industry Guideline in Europe. And I hope that was helpful for you to show you what is the best practice, what is a kind of standard procedure that you might apply when you are an international operating life science company. And I don't know, Mark, if there are some questions in the chat room.
Yes, we do. We have one question before we transition over to Ned. The question is if you could please confirm that the EU countries with transparency laws are applicable to both pharmaceutical and device manufacturers, or do they differ from country to country, association to association?
They apply to both. And so the only thing where they differ is different thresholds, payments maybe to governmental officials. So in Italy, and also the National Sunshine Act in the UK, they only ask for a disclosure of payments to the NHS, so to physicians that are employed at the National Health Service. But in any case, these national sunshine laws applies to both type of products. And again, referring to France, France even asks the producers of cosmetics to disclose any kind of payments.
Interesting.
Thank you. That's the last question for that section. We'll go ahead then and transition over to Ned Mumtaz to talk about some practical approaches and best practices from what we just heard from the two previous sections.
Thank you, Mark, and thank you, team. Very enlightening in terms of the new regulations. I did spend a year in Europe supporting transparency, so it was interesting to see some of the changes that have taken place since. So my name is Ned Mumtaz. I'm a compliance director at Vector Health. Before joining Vector Health, I worked in the pharma drug industry for approximately 20 years. I worked for Wyeth, now Pfizer. I worked for Schering-Plough, now Merck. So at the time, people were hiring me if they wanted to get acquired. No, but seriously, then I moved to a couple of Japanese pharma companies. And so in the process, I've had an opportunity to get deeper understanding of both US transparency and compliance reporting requirements, European and Japanese, and a couple of other regions. So what I would like to do is maybe look at this information from the standpoint of compliance operations and share with you what are some of the best practices. We are working with several clients in helping to address all these changes, especially this sort of global movement to increased transparency that started in 2011 or so with the Federal Sunshine Act in US and Bertrand Law in France, and now it has pretty much mushroomed much widely. So that said, let's dive into it. Maybe what are some of the core capabilities if you are starting to establish a capability for transparency, both in US and ex-US or OUS? What are some of those features that are very common that you would need? The first part is pretty self-explanatory. You need to collect spend, and you need to be flexible in how you do so for several reasons, because the reporting requirements from a global standpoint vary significantly. Those of you who have experience in US realize that CMS, which may take a big component of your total spend reporting, you still need to apply additional data collection steps for different states where there are additional reporting types, additional covered recipient types, and so forth. The next part is where I feel the real value of your program comes in, that your organization expects you to supply, and that's in establishing quality of information. So you are verifying the spend that has come in, you are managing any exceptions and errors, and then you are publishing reports meeting the specifications for each precinct. So a lot of rigor you may want to consider in establishing QA. I've worked with over 150 drug and device manufacturers, and consistently that's one guidance I have provided, that each year you want to have continuous improvement in your QA capability. We have worked with clients where we have around 400 plus QA checks in your federal and state and global reports. The third part around analyzing spend, the total volume of transactions that even small to mid-sized manufacturers today manage is very large. And when you look at that at the industry collective level, that volume is extremely high. So I feel we are past the point, or may have been past the point, where you could do all that gymnastics on your Excel sheet to understand where your spends are. And as the councils very capably shared with you, you have responsibilities in around 4 spheres. The first one is just administratively to collect the spend at transaction level. That may seem simple, has some nuances where you might miss some spends. The second part is collectively, you need to make sure that there are no surprises in your spend that are showing up. And that is an area where collectively you begin to see that. The third space is benchmarking, very important. You may want to start benchmarking, especially when you have this many precincts to cover, if you are a global organization, to see if there are significant variances year over year. And then lastly, benchmarking against industry. You're working with an HCP who may have been receiving honoraria from you. Is the industry also valuing him as a knowledge expert? Are others working with him, and so forth? So I think that's an area which is now getting a lot of attention in the industry. And then lastly, matching HCPs. That has always been a cornerstone for establishing any successful compliance reporting program. But what's more significant now, certainly in US, is that you've added a fair number of additional covered recipients. So if you could get away with doing some of that matching a bit more manually, you might need to come up with a program where there is more sophistication in how you match your HCPs and all the mid-level practitioners. So those are the 4 components I would call out. are very common, very standard if you are running a program in US for state reporting and OUS. Next slide, please. And I also want to call out, we have around 6 to 7 minutes. If you have questions, please feel free to send those in. We will address those. And if there are any questions we miss, we will certainly follow up through email and get those questions answered. So I mentioned 400 plus quality checks. These are just illustrative. Again, in the interest of time, I won't go into those, but the message is the strength of your quality checks establishes the strength of your transparency reporting program. This is what keeps organizations out of trouble if you have a very formal, very in-depth QA/QC program. Next slide, please. We heard of changes, especially around CMS, significant changes that have recently come in. And let me dive into both of those in the next couple of slides. The top two ones, which is additional HCPs and unique device identifiers. Next slide, please. So this is a quick pie chart, a quick summary. What's on the left are the covered recipients that have currently been in place for the last 5-6 years. What's on the right are expanded covered recipients. So you can observe that there's nearly 25% increase, but the variety or the different types of specialties and different types of HCPs that have been added is significant. So two important messages from a best practice standpoint. Number one, you may want to retrain your field and your expanded team that collects spend to be vigilant about these additional covered recipients. And then secondly, establish much more robust HCP matching. Next slide, please. I'll continue over to maybe the following slide. I might skip a few slides, but I'll make sure that the key messages are covered. So on the unique device identifiers, 3 key messages. The device identifiers are mandatory and they need to be reported for device manufacturers. It is a fixed portion of the label, which includes the manufacturer information and then the specific device. There are additional device information that's optional that you may not need to report. You have a couple of good sources to go to. One is the Global Unique Device Identification Database. You can go, and if you want to download just to have your colleagues know all the device IDs for your organization, you can go there. And in this example, the device ID is what I have highlighted, which is reportable. You might also add the descriptor if you choose. Next slide, please. Quick illustration of a device that has multiple components. In this case, you might have a couple of choices. If you are very keen, since you can report up to 5 devices, you might include all the device IDs of both the overall package, which is the one highlighted in red on top, and as well as the components, or you might choose just the overall package because that's inclusive of some of those other components. I have around 3 minutes left. I'll try to cover 3 next topics real quick. And again, if you have questions, please bring them in. I'm moving to some of the impact of, I think Cord covered the GDPR and the consent management very comprehensively. So I'll move on to the next topic, which is impact of some of the guidances that organizations have received based on the OIG Fraud Alert and the DOJ. We've been asked that question very often in the past 5 months. What can organizations do to bolster up the risk that this alert introduces? This is a quick eye chart on things you can do. What's very common in here is monitoring and analytics. I'll just call out on it. Several types of those concerns that were raised by the OIG alert are very standard in monitoring of your speaker programs that many organizations today have established through a comprehensive monitoring and analytics program. These are very simple volume-based things, such as attendees without the right specialization or without the right type attending an event. If the given attendee has attended the same event multiple times. These are very quick and easy to catch. There are some which are more involved, more complex, and we don't have the time, but at some point, we'd be happy to follow up and present those. Next slide, please. With respect to the DOJ settlements, again, any comprehensive transparency program would have caught some of the scenarios that we heard. Scenarios where your accounts payable system has made a payment and your transparency or your compliance reporting may not have identified those. So one of the key steps that you all perform with respect to reporting compliance, spend, and transparency is delineating what's reportable and what's not. So if as an organization you feel that there is weakness, you may want to broaden that net of bringing in your transactions from accounts payable, from expense reporting system, before you sift out what you may consider reportable and what you may consider non-reportable. That might help with some of these challenges. And again, a more in-depth topic for a discussion, but suffice to say, there are plans and very specific capabilities that some of the organizations have in place to protect them against some of these risks that were observed. I think we are hitting the time, so I might just go to one or two quick illustrations because I'm speaking sort of anecdotally of some of these capabilities. I'll take a minute to just show you visually what some of these capabilities might look like. So Mark, if you might help me maybe run to the last couple of slides. What they reflect, what they represent are the types of benchmarks organizations who have established an analytics and monitoring capability are able to perform. They can benchmark against history of their own spend, which is on the top left, by specialty. They can benchmark against the types of spend. This begins to give them indications if there are sudden variations in their spend types. Then on the top right is an interesting one. A lot of folks in the industry take huge interest in it, and that is benchmarking the spend at a given HCP level. So that's showing what are the different spends that you have with a given HCP year over year. If you see suddenly a new spend type showing up, maybe consulting, maybe on a area with someone who has not been in your spend list for a while, as a compliance leader in your organization, that's something you may want to go and look deeper from an FMV standpoint, and then also compare it against the industry, which is on the bottom right. Next slide, please. I'll just cover one or two more slides on this. So this is based on actual real data. This is based on CMS data set. And I'm trying to make a point with this slide. The point I'm trying to make is Takeda recently acquired Shire. Takeda acquired a couple more companies in the last 5 years. Shire acquired a couple of companies in the last 5 years. Now, as a compliance leader, if you're doing benchmarking for Takeda, you would want to have all those different organizations included in your spend transaction records in order to do meaningful benchmarks. So you can do year-over-year comparison. So this takes me back to the very first slide where I was referring to the need for organizations now, especially compliance organizations, to move into a bit more of industrial strength capability around analytics and monitoring, because the volume and the sophistication of data is now present. Especially the regulators, OIG, DOJ, as well as globally, are utilizing those capabilities. They're utilizing data scientists. So at the minimum, you would want to know what some of the regulators, as well as others in the industry, might be seeing about you. So you want to be in a strong position to have that visibility into all those transactions, all those spends that are happening. And without industrial strength, quality assured capability, you begin to have a weakness and a competitive disadvantage in knowing some of those challenges with respect to your spend oversight that you may be expected by your leadership in the organization. Last slide, please. So this is taking that whole information at a global level. Now, of course, we learned that, we heard that today, very clearly, very comprehensively, that different precincts for certain have very different reporting needs. And certainly the GDPR requires an additional step for those of you who work in EU to collect consent. But as a compliance leader, you need a central console to know what that spend activity is, at the minimum benchmark year over year. So this is a dashboard. It's assembled in a very common tool. Pharma companies have that very frequently, Tableau, that provides you the ability to get that global look. Now, you have to make certain decisions in creating a common match across US, France, UK, South Korea. Of course, each of those precincts and many more have very specific spend types. But in US, if you have 4 different types that all sort of equate to consulting type services for education, a non-educational event, just consulting fee, just honoraria. Yes, all those nuances are important for your transparency payment, but as a compliance leader, when you are comparing that spend across the globe, some of those differences can be condensed into what I've written here as fee. And you would find that that type of payments are very much prevalent and applicable in other precincts. So I'll close with that sort of feedback from a best practices standpoint. You want to consider staying a step ahead of A, what the regulators are looking, and B, what your leadership is expecting from you with respect to oversight. I'll close with a quotation or with a sort of sharing an event that I attended. This was a CBI conference 3 years ago. 4 chief compliance officers were on the podium and they were asked this question: what keeps you up at night? And interestingly, all 4 essentially said the same thing. Their response was, over the past few years, compliance organization has become the keeper of very large volume of information. And that information comes from many different sources, from R&D, from research, from commercial, from marketing, from medical services. And so there is an expectation that at the time of attestation, someone in a leadership position in the compliance is satisfied to attest to all those spends. And all 4 CCOs said they feel they don't have sufficient tools and the necessary tools to make that comprehensive decision. So if there's one message in all these DOJ and OIG alerts that have come in and all these regulatory changes that are happening that I could give you from a practical standpoint in applying and operationally enabling your organization to manage it, I would say that you may want to consider exploring even rudimentary capability for getting visibility and knowledge of what those spends are across precinct. That's all I have. Thank you very much. Sorry that I went over by a couple of minutes. And as I said, if there are questions, please do send those in, write them in. We'll do our best to address those. Mark, over to you.
Thank you, Ned. And on behalf of FieldFisher and Gardner Law and Vector Health, we would want to thank everyone for attending this webinar, particularly those who've spent a few minutes here going over with us. So thank you again for that. And I'll look just to Mark Gardner and Cord Wilhurst for any last minute closing comments here.
No, I echo your thanks and a lot of questions come up.
Same from my side. Thank you very much for being part of this very interesting webinar tonight, or this morning from your views. Thank you very much. And if anyone has a question that I have not heard or could not answer, please reach out to me. I'm happy to help. Thank you very much.